SSA Section 1101 Subsection D Child Support and Other Resources. At best kept secret 510. S. 1101. 42 U.S.C. 1301. When used in this Act. 1. The term state, except where otherwise provided, includes the District of Columbia and the Commonwealth of Puerto Rico, and when used in Titles IV, v. 7, 11, 19, and 21 includes the Virgin Islands and Guam. Such term when used in Titles 3, Ix, and 12 also includes the Virgin Islands. Such term when used in Title V and in Part B of this title also includes American Samoa, the Northern Mariana Islands, and the Trust Territory of the Pacific Islands. Such term when used in Titles 19 and 21 also includes the Northern Mariana Islands and American Samoa. In the case of Puerto Rico, the Virgin Islands, and Guam, Titles I, X, and 14, and Title 16 as in effect without regard to the amendment made by Section 301 of the Social Security Amendments of 1972, 3, shall continue to apply, and the term state, when used in such titles but not in Title 16 is in effect pursuant to such amendment after December 31, 1973, includes Puerto Rico, the Virgin Islands, and Guam. Such term when used in Title XX also includes the Virgin Islands, Guam, American Samoa, and the Northern Mariana Islands. Such term when used in Title IV also includes American Samoa. 2. The term United States, when used in a geographical sense means, except where otherwise provided, the states. 3. The term person means an individual, a trust or estate, a partnership, or a corporation. 4. The term corporation includes associations, joint stock companies, and insurance companies. 5. The term shareholder includes a member in an association, joint stock company, or insurance company. 6. The term secretary, except when the context otherwise requires, means the Secretary of Health and Human Services. 7. The terms physician and medical care and hospitalization include osteopathic practitioners or the services of osteopathic practitioners and hospitals within the scope of their practice as defined by state law. 8. A. The federal percentage for any state other than Puerto Rico, the Virgin Islands, and Guam shall be 100% unless the state percentage, and the state percentage shall be that percentage which bears the same ratio to 50% as the square of the per capita income of such state bears to the square of the per capita income of the United States, except that the federal percentage shall in no case be less than 50% or more than 65%. B. The federal percentage for each state other than Puerto Rico, the Virgin Islands, and Guam shall be promulgated by the Secretary between October 1 and November 30 of each year, on the basis of the average per capita income of each state and of the United States for the 3 most recent calendar years for which satisfactory data are available from the Department of Commerce. Such promulgation shall be conclusive for each of the 4 quarters in the period beginning October 1 next succeeding such promulgation, provided that the Secretary shall promulgate such percentages as soon as possible after the enactment of the Social Security Amendments of 1958, 4, which promulgation shall be conclusive for each of the 11 quarters in the period beginning October 1, 1958, and ending with the close of June 30, 1961. C. The term United States means but only for purposes of subparagraphs A and B of this paragraph the 50 states and the District of Columbia. D. Promulgations made before satisfactory data are available from the Department of Commerce for a full year on the per capita income of Alaska shall prescribe a federal percentage for Alaska of 50% and, for purposes of such promulgations, Alaska shall not be included as part of the United States. Promulgations made thereafter but before per capita income data for Alaska for a full 3-year period are available from the Department of Part A, General Provisions. DEFINIT ions. Commerce shall be based on satisfactory data available therefrom for Alaska for such 1 full year, or, when such data are available for a 2-year period, for such 2 years. 9. The term, shared health facility, means any arrangement whereby, a. 2 or more health care practitioners practice their professions at a common physical location, b. such practitioners share, I. common waiting areas, examining rooms, treatment rooms, or other space, e. the services of supporting staff, or e. equipment, c. such practitioners have a person who may himself be a practitioner, I. who is in charge of, controls, manages, or supervises substantial aspects of the arrangement or operation for the delivery of health or medical services at such common physical location, other than the direct furnishing of professional health care services by the practitioners to their patients, or e. who makes available to such practitioners the services of supporting staff who are not employees of such practitioners, and who is compensated in whole or in part, for the use of such common physical location or support services pertaining thereto, on a basis related to amounts charged or collected for the services rendered or ordered at such location or on any basis clearly unrelated to the value of the services provided by the person, and d. at least one of such practitioners received payments on a fee for service basis under Titles 18 and 19 in an amount exceeding $5,000 for any 1 month during the preceding 12 months or in an aggregate amount exceeding $40,000 during the preceding 12 months, except that such term does not include a provider of services as defined in Section 1861U of this Act, a health maintenance organization as defined in Section 1301 of the Public Health Service Act. 5. A hospital cooperative shared services organization meeting the requirements of Section 501E of the Internal Revenue Code of 1954, 6, or any public entity. 10. The term, administration, means the Social Security Administration, except where the context requires otherwise. b. The terms, includes, and, including, when used in a definition contained in this Act shall not be deemed to exclude other things otherwise within the meaning of the term defined. c. Whenever under this Act or any Act of Congress, or under the law of any state, an employer is required or permitted to deduct any amount from the remuneration of an employee and to pay the amount deducted to the United States, a state, or any political subdivision thereof, then for the purposes of this Act the amount so deducted shall be considered to have been paid to the employee at the time of such deduction. d. Nothing in this Act shall be construed as authorizing any federal official, agent, or representative, in carrying out any of the provisions of this Act, to take charge of any child over the objection of either of the parents of such child, or of the person standing in loco parentis to such child. 3 L 92-603, Section 301, added Title 16, Supplemental Security Income for the Aged, Blind, and Disabled. 4. August 28, 1958 PL. 85-840, 72 Stat. 1013. 5. See Volume 2, PL 78-410, Section 1301, 6. See Volume 2, PL 83-591, Section 501 EPL 99-514, Section 2, provides, except when inappropriate, that any reference to the Internal Revenue Code of 1954 shall include a reference to the Internal Revenue Code of 1986. LEI greater than WEX greater than child support. Child support refers to the sum that the non-custodial parent must pay to the custodian. This sum serves as a parental contribution for the child's basic living expenses, such as food, clothing, shelter, health care, and education. When a court orders a parent to pay child support, the parent must pay directly to the child's custodian rather than directly to the child. States generally do not impose an obligation to pay support for a child after that child has reached the age of 18. An individual, however, only has a legal responsibility to support one's own biological children. Thus, A court cannot order an individual to pay child support for a stepchild, subject to the caveat that the individual did not formally adopt the stepchild. While the vast majority of states adhere to this rule, a few state statutes differ with regard to stepchild support. To determine the law in a particular jurisdiction, see state laws. Trial courts determine the amount of the periodic installments for the parent to pay. The amount varies between cases, taking into account the unique circumstances of each case. Circumstances include the child's age, the health and educational needs of the child, and the standard of living that the child would have enjoyed if the family had continued living together. States differ on the exact methodology for calculating the amount of child support owed. Generally, however, courts will make specifications regarding both the custodial and non-custodial parent's net monthly income. Many statutes require a parent to pay a set percentage of the parent's annual salary. Some statutes also require parents to pay a percentage of any bonuses received as well. The Uniform Marriage and Divorce Act requires parents to pay an amount reasonable or necessary for the child's support without regard to marital misconduct. Factors in determining reasonableness or necessity include the child's financial resources, the custodial parent's financial resources, the standard of living. The child support. Child support. An overview. Lei greater than wex greater than contract. Under the benefit detriment theory, an adequate consideration exists only when a promise made to the benefit of the promisor or to the detriment of the promisee, which contracts arise when a duty comes into existence, because of a promise made by one of the parties. To be legally binding as a contract, a promise must be exchanged for adequate consideration. There are two different theories or definitions of consideration: bargain theory of consideration and benefit detriment theory of consideration. A contract is an agreement between parties, creating mutual obligations that are enforceable by law. The basic elements required for the agreement to be a legally enforceable contract are mutual assent, expressed by a valid oath or an acceptance, adequate consideration, capacity, and legality. In some states, elements of consideration can be satisfied by a valid substitute. Possible remedies for breach of contract include general damages, consequential damages, reliance damages, and specie performance. Contracts are promises that the law will enforce. Contract law is generally governed by state common law, and while general overall contract law is common throughout the country, some specie court interpretations of a particular element of the contract may vary between the states. If a promise is breached, the law provides remedies to the harmed party, often in the form of monetary damages, or in limited circumstances, in the form of specie performance of the promise made. Contract. Background. Elements. Consideration and mutual assent. Benefit detriment. Guidepost. https://www.law.cornell.edu/wex/contract. The key is child support as a contract. Problem is a person can go file for child support and bind you into an agreement you did not have knowledge or agree to. A contract must be signed by two competent people and full disclosure must be made. So now your question should be, is it a real binding contract? Did you ever sign or get full disclosure? Did you or was there ever a paternity test to prove that is your property? Yes, property, wife, kids, assets all looked upon as property in court. So how do you get out of a contract? Also, this is an alleged debt, so you need proof. Validation. Also, people must remember we are two in one and we never claim our property or put liens on our property. Reason: you want to take control of the entities the system created. Your alleged debt is mailed in all caps. That is improper English. It is your entity they are going after. Corporations can only do business with corporations, not living beings. So I had my people do a assumed name certificate. I wanted to make sure there is no misunderstanding of the entity and living soul handling the business. You want to do your due process. That means put people on notice. Rescind contract, because it was unknown ly. Then, it's time to request validation in all books of account. Putting the codes and CFRs to back up what you are claiming. All roads lead to court. Remember that. I had a friend and he came to me needing help with child support. He was paying for a kid that wasn't even his or even had knowledge he was paying for this factitious child. He stated he paid for paperwork and really nothing happened. I wrote one letter and got movement. Long story short, he got his license back and his alleged debt went from in the thousands to I think it was like 68 cents. Lol, plus threats of suspending his license if he didn't pay. They were trying to intimidate him to recontract. The cases was closed and I have posted proof before. I think on my Snap or Instagram. His fight still wasn't over cause they bullied him, made his life a living hell. He stood strong and continued to prove and dig. I did tell him don't get caught in the rabbit hole, it gets deep. The goal is now to protect your assets. Let me tell you true story. Title, Section, U.S. Code. LEE greater than U.S. Code greater than Title 42 greater than Chapter 7 greater than SUBCHAPTERIV greater than Part D. Section 651. Authorization of Appropriations Section 652. Duties of Secretary Section 653. Federal Parent Locator Service Section 653A. State Directory of New Hires Section 654. State Plan for Child and Spousal Support Section 654A. Automated Data Processing Section 654B. Collection and Disbursement of Support Payments Section 655. Payments to States Section 655A. Provision for Reimbursement of Expenses Section 656. Support Obligation as Obligation to State. Amount. Discharge in Bankruptcy Section 657. Distribution of Collected Support Section 658. Repealed. Pub. L105200. Title II, Section 201F1, July 16, 1998, 112 Stat. 657. Quick search by citation. Go. Section. Enter Title 42 U.S. Code Part D, Child Support and Establishment of Paternity. LEE greater than Electronic Code of Federal Regulations ECFR, greater than Title 45. Public Welfare greater than Subtitle B. Regulations relating to Public Welfare greater than CHAPTER 3. Office of Child Support Enforcement, Child Support Enforcement Program, Administration for Children and Families, Department of Health and Human Services. CFR. Part 301. State Plan Approval and Grant Procedures, Sections 301.0 301.16, Part 302. State Plan Requirements, Sections 302.0 302.85, Part 303. Standards for Program Operations, Sections 303.0 303.109, Part 304. Federal Financial Participation, Sections 304.10 304.95, Part 305. Program Performance Measures, Standards, Financial Incentives, and Penalties, Sections 305.0 305.66, Part 306. Reserved, Part 307. Computerized Support Enforcement Systems, Sections 307.0 307.40, Part 308. Annual State Self-Assessment Review and Report, Sections 308.0 308.3, Part 309. Tribal Child Support Enforcement IVD Program, Sections 309.01 309.170, Part 310. Computerized Tribal IVD Systems and Office Automation, Sections 310.0 310.40, Parts 311 to 399, reserved. 45 CFR Chapter 3. Chapter 3. Office of Child Support Enforcement, Child Support Enforcement Program, Administration for Children and Families, Department of Health and Human Services. CFR State Regulations. LEE greater than Electronic Code of Federal Regulations ECFR, greater than Title 45. Public Welfare greater than Subtitle B. Regulations relating to Public Welfare greater than CHAPTER 3. Office of Child Support Enforcement, Child Support Enforcement Program, Administration for Children and Families, Department of Health and Human Services greater than Part 302. State Plan Requirements greater than Section 302.56 Guidelines for Setting Child Support Orders. Within 1 year after completion of the state's next quadrennial review of its child support guidelines, that commences more than 1 year after publication of the null rule, in accordance with Section 302.56e, as a condition of approval of its state plan, the state must establish one set of child support guidelines by law or by judicial or administrative action for setting and modifying child support order amounts within the state that meet the requirements in this section. B. The state must have procedures for making the guidelines available to all persons in the state. C. The child support guidelines established under paragraph A of this section must at a minimum 1. Provide that the child support order is based on the noncustodial parent's earnings, income, and other evidence of ability to pay that. 45 CFR Section 302.56 Guidelines for Setting Child Support Orders. Section 302.56 Guidelines for Setting Child Support Orders. For complaints, put name, address, capacity in propria persona, etc. My cause of complaint and subject matter objection on child support. I object under SSA Act. Cause of Acts. SSA Section 1101 subsection D. Nothing in this act shall be construed as authorizing any federal official, agent, or representative, in carrying out any of the provisions of this act, to take charge of any child over the objection of either of the parents of such child, or of the person standing in loco parentis to such child. You can't charge me for my property, children. 2. Cause of Acts. Title 18 U.S.C. Section 242(3). Cause of Acts. Law enforcement misconduct. Statute 42 U.S.C. subsection 14141, etc. The pic is on the next page. I posted the full format on my Instagram Beautiful510. I am not about to write it over. At least you get the gist of the verbiage. I am not an attorney, it's just information I read and my understanding on how things should be formatted and putting people on notice. This information I posted 2020. Do your own due diligence. Hope you enjoyed. I'm only a guidepost, you must do your own due diligence and go read. Everyone has a different situation. Refer to law and government sites. The information is there to read. Then learn how to properly put people on notice through the courts, which in previous videos I have showed that as well.